Jodi Arias, Karma. Jodi Arias' attorney asked for natural life. Does the sentence consideration fit the crime? Basically, the memorandum states that the attorneys for Jodi Arias attached a list containing 60 cases involving defendants who were convicted of first-degree murder and were sentenced to life in prison with the possibility of parole. An analysis of these cases demonstrates that Ms. Arias' conviction is similar to a number of other cases involving defendants who were similarly situated and received a sentence of life with the possibility of parole after 25 years. It further reads that examples of cases where defendants received a life sentence with the possibility of parole keep occurring. I refuse to list the names and crimes of those other defendants because I see no relevance to their crime and the crime committed by Jodi Arias. Nermes and Wilmot's articles of bullshit. As of the filing of this memorandum, there is another example where the defendant was a 2-year-old child. The defendant squeezed the child until it stopped breathing. The baby struggled 5 or 6 times to get free, but the defendant continued squeezing harder until it stopped breathing. The attorneys writing the memorandum referred to the Arizona Republic article titled Gilbert Dad Sentenced to Life for Killing Son, dated April 9, 2015. Despite the young age of the victim, the amount of time and trusted relationship between defendant and victim, this defendant was sentenced to life in prison with the possibility of. In my opinion, in this matter, this approach by the attorney was sick and has no concept of the word suffering. In my opinion, this lost and loses the translation somewhere between the truth and the lies that have been abundantly told during the trial with help or coaching. These attorneys have a reputation for representing child killers and molesters and show no sensitivity to these kind of crimes, making logic and rationale flawed to fit the crime and sentencing process. This example cited does not take into consideration the fact that this defendant, this child killer, is a dead man walking, as his crime has a punishment attached to it separate from the one of the judge in this case cited. The judge knows this man is a dead man walking and knows this man will never survive doing his complete sentence as he stands to be murdered before his time is up and served. Only ignorance of the prison culture keeps me from laughing at this interpretation. Child abuse, child killings, and child-related crimes are death sentences for those who commit them. No matter how naive a person is, this is the truth. Jodi Arias did not kill a child. She killed and murdered a full-grown adult male who was ambushed and slaughtered as he's described as an individual who had a trusting relationship with Jodi. Like the child cited in the example, Travis Alexander was betrayed. This crime is not and has not been a crime similar to or equal to the tragedy and brutality of the attack on Travis Alexander. This crime should be treated on a case-by-case basis, and the severity, the premeditated and acute planning of committing a homicide illustrates the cruel and deliberate state of mind to kill him for jealousy and revenge. Such loss of control should be recognized as a potential for future violence, as well as a poor indicator of ever being reformed or rehabilitated again. The judge should take in consideration the following factors to make her decisions: the motive, the means to justify her actions in killing someone with malice, the purpose of the homicide, why she did this horrific act, the viciousness and total disregard of human life and manner executed, the wickedness and methodology of the crime committed in violation of trust, her state of mind and future potential to commit violence again being unstable. All the mitigating factors in this case have been formulated and designed or created by the defense team to justify criminal behaviors. Her not having a prior history of criminal behavior has been trumped by the fact she committed a capital crime subject to the death penalty, and although not sentenced to death, the severity does not lessen just because death was not found to be the sanction for this case. Her propensity for violence has been demonstrated. She cannot be trusted to walk free and allowed to have opportunity, ability, and proximity to any future victim within her realm of presence. Based on the findings of Jodi Arias' mental status, the state should not take it for granted she will not kill again. Her weaknesses are the same strength she used to kill Travis Alexander. To boldly state to the community is not a risk, is a foolish presumption, and cannot be relied upon to be evidence-based, accurate, as Jodi Arias has exhibited behavior that's been determined by the MMPI-2 to show variances in ego strength, aggression, anger, self-esteem, hostility, and dominance. Certainly not qualities or core values that are dependable and showing stability. It is argued that these 2 minutes in Jodi Arias' life do not accurately reflect her characteristics and personality disorder. She is described as having a peaceful, passive, and non-aggressive nature. The attorneys attempt to deflect the fact that shows Jodi Arias is not prone to any future violence due to not being a member of a gang, no drug abuse history, or other disruptive behavior, including previous felony convictions. And then the attorney throws out a big but. But Jodi Arias has a diagnosable illness. She has borderline personality disorder, something she was born with, and beyond her self-control. They, the attorneys, blame society and the family for Arias' illness, citing a lack of supportive background in her life. They blame abusive childhood for her anger and other diagnoses found, and cite this is beyond the afflicted person's control. They cite post-traumatic stress disorder suffered during childhood, making a case for pity rather than for reason. These episodes of trauma occurred in her childhood, including being physically and emotionally abused, including an incident at being held at knife point. He further describes her instability to cope and function based on all these events in her life, permanently impacted, I might add, as they do not erode, devaluate, shrink, or go away while incarcerated. In fact, they may become worse due to lack of availability of treatment while incarcerated. Jodi Arias suffers from deep, severe depression. Jodi Arias suffers from suicidal thoughts. Not once did the attorneys identify the art of manipulation. Stability factors. The attorneys explain no excuses, but there are real reasons for why she committed homicide, and therefore should be given sympathy and empathy in her struggles in life. The attorneys claim denied or not giving the consideration by the state for suffering from a mental illness, unlike other defendants, building a case where he believes Jodi Arias is the victim of being mentally ill and the state is victimizing the mentally ill and punishing them to the extreme without reason. This list of mitigating factors does not mention Travis Alexander once as the real victim, as this attorney paints Jodi Arias' life as a puzzle, disharmonized, traumatized, or paralyzed by the mental illness, personality disorders, bizarre behaviors, and not once her motive for killing Travis Alexander, asking for a life sentence with the possibility for parole at 25 years. This would put Jodi Arias in the age group of approximately 60 years old. On the other hand, Travis Alexander died a young man at the hands of this convicted murderer. Not once are his rights represented in this memorandum to spare the killer natural life inside of an Arizona prison. On April 13th, Jodi Arias will face Judge Honorable Sheriff Stevens in the courtroom. I hope the judge sentences her to life without parole.